we're going to be talking about civil suits. It's important for us to deal with these because most of our cases are going to involve lawsuits to assert their First Amendment rights. We're going to use the McDonald's hot coffee suit to explain the process because most people will have heard of it. It is passed into urban mythology and often is invoked by those people who wish to restrict the rights of people to sue for damages. It's called Liebeck versus McDonald's. Liebeck is the plaintiff. McDonald's is the defendant. The plaintiff's name goes first. The defendant's name goes second at the trial court level. The injury that Ms. Liebeck sued over occurred in 1992. She was at the time 79. She was a passenger in a car driven by her grandson that went through a McDonald's drive-thru. Now, much of the misinformation about this suit was that she was driving a car, spilled the coffee while she was driving, and then sued McDonald's for serving coffee that was hot. Part of it's true, much of it's not. She's a passenger. They got breakfast, she got a cup of coffee. Her grandson stopped the car so she could put the cream and sugar in her cup. She put the cup between her thighs. When she pulled off the lid, the coffee spilled. Ms. Liebeck suffered third-degree burns on her thighs, lap, buttocks, and other parts, totaling 6% of her skin. You need to understand, first-degree burns, second-degree burns, third degree. Third degree is the most serious, and it involves the destruction of the skin. She was in the hospital for 7 days. She underwent skin grafts. Skin grafts are kind of like farms that grow turf. Every so often they'll send a machine in and it will use a sharp edge to go under the turf, which is then rolled up, sold to a consumer who will then unroll it on a new lawn. Well, skin grafts require the same sort of thing. There's a sharp object, it's slid under the skin, and then it rolls along, scraping up skin and its underlying support cells, which then can be put down in another part of the body. That's part of what Ms. Liebeck went through. She asked for $20,000 because that's how much it cost her for her medical expenses. McDonald's said, "We're not responsible, but we'll give you $800 if you go away and don't bother us again." Having been rebuffed, she sued. Civil suits start with injury. For our cases, sometimes the injury will be the violation of First Amendment rights. In the beginning of the suit, we have to have a complaint and service of process. The complaint has to allege the facts that the plaintiff says caused injury. In the complaint, Ms. Liebeck said that she was injured because McDonald's was serving coffee that was inherently dangerous. It talked about when she was burned, the results of the burns, and that complaint is part of service of process. That's where the defendant is told that he or she is being sued. It's a requirement before any lawsuit can go forward. Following service of process, the defendant must answer. If you don't answer, then you are subject to default judgment, which means you've forfeited the lawsuit. In the answer, you can do a couple of things. You can deny everything, or you can admit to some things, deny others, or you can just say, "You're right, I did a terrible thing." We have very few of those sorts of answers because Darwin takes care of those defendants before they ever get in a position to injure anybody else. In this case, McDonald's said, "We have no liability because everyone knows coffee is hot, and if you spilled it on yourself, then that's your own lookout." After we have the complaint, the service of process, and the answer, we move into discovery. Very important part of the case. Discovery is the process of learning the cards that your opponent has. It's kind of like playing poker where everybody has to show their cards. It is intended to help resolve suits before they have to go to trial. Because if you know the other guy's cards and you know that he's got a pair of threes and the other guy sees that you have a full house, then he's not going to bother going through the process of betting and then calling and then finally showing the cards and losing. He will be inclined to settle. A second reason for discovery is to avoid what is known as trial by ambush. That's a process that takes place in some television shows about lawyers. And it is when, in the middle of a case, a lawyer springs a surprise witness or hitherto unsuspected evidence, and then the case comes to a successful conclusion for the hero lawyer. That's not supposed to happen in real life. Discovery and the evidence that comes from discovery is supposed to be known to the parties, and if a party objects to evidence, then that objection needs to be dealt with before they start the trial. Trials take long enough, and judges don't want to have to stop things and consider a motion to admit or to disqualify evidence, in part because they're going to make a decision right there from the bench, and they're more likely to make a mistake, and judges don't like to be caught making mistakes. Discovery consists of several different tools. One is admissions. And in admission, you send a document to the other side asking them to admit certain things. In the Liebeck versus McDonald's suit, McDonald's would send admissions to Miss Liebeck saying, do you admit that your name is Mrs. Liebeck? Do you admit that you live at this address? Do you admit that you were in the United States on the day of the claimed injury? Miss Liebeck will send admissions to McDonald's saying, do you admit that you are the owner of the McDonald's at this particular address where I was injured? Interrogatories are written questions. They're a little more detailed than an admission. Instead of do you admit, an interrogatory will say, explain what you did that caused the injury. So in the interrogatories, Ms. Liebeck's lawyers will ask McDonald's to explain how they decided what temperature to serve the coffee and how many reports of injuries they had. For McDonald's, they'll ask Ms. Liebeck who she went to see for treatment, if she had any prior medical problems that would have required skin grafts. Along with interrogatories, we have requests for production. You have to produce something for the other side to see. So in the Liebeck versus McDonald's case, McDonald's would ask Mrs. Liebeck to produce her medical records so that the McDonald's doctors could look them over and say, oh, well, this is obviously not the result of a coffee burn. This looks like it was the result of some other problem. Miss Liebeck, for her part, could ask McDonald's to produce the coffee maker that was used to prepare the coffee that burned her, so that Miss Liebeck's experts can say, this is how it works, determine if it's working properly, find out about the process of storing and holding the coffee at a particular temperature. Then we have depositions. In depositions, you're sitting in a room, your lawyer, the other lawyers, and a court reporter. Each side has the opportunity to ask questions, although generally it's the other side asking questions of your client or your expert. You don't necessarily want to ask questions of your own client or expert because that'll give away part of your strategy. What is said in deposition is sworn testimony. It is as testimonial as testimony from the witness box. And it comes into the courtroom just as if you had testified in the courtroom earlier. So you have to be careful. In discovery, the process, McDonald's said it had 700 complaints about injuries from the temperature of its coffee in the decade before Ms. Liebeck was injured. McDonald's also said in discovery that it held its coffee at between 180 and 190 degrees to provide the optimum taste. But in discovery, McDonald's quality assurance manager said that the coffee was so hot that it could not be drunk as soon as it was poured. We go through the process of discovery, we finish discovery, everybody's ready to go to trial, and we go to trial. You have opening statements by both sides. Now, frequently, both sides will make opening statements at the beginning of the trial. Sometimes the defendant will reserve an opening statement until the defendant presents his or her case in chief. The opening statements, you must remember, are not evidence, so they don't have the weight of testimony. But in the opening statement, the lawyers lay out the idea of the lawsuit. This is the theme we're going to be using. This is what we're going to show you with respect to the defendant's conduct that caused the injury. This is how you'll see that the defendant is responsible for Ms. Liebeck's injuries. And of course, the defense will make its opening statement. Everybody knows coffee's hot, and everybody knows you should be careful. And if you're not careful and you spill something on yourself, the evidence will show Ms. Liebeck was responsible for everything. After the opening statements, the plaintiff puts her case on first. This is her case in chief. She puts forth witnesses. They are asked questions on direct examination. Then, after the plaintiff's lawyer has finished direct examination, the witness is passed to the defense lawyer, who gets to ask the witness about things that the plaintiff's lawyer asked, perhaps in an effort to undermine the credibility of the witness, to show weaknesses in the plaintiff's story. The witnesses are also important because the witnesses help bring in evidence. Evidence comes from the witness box. You might have the McDonald's coffee maker sitting on the plaintiff's table. That evidence doesn't come into court until a witness testifies that that, in fact, is the McDonald's coffee maker that was used to make the coffee that injured Ms. Liebeck. Evidence can't speak for itself, so it always has to have a witness to show that it is relevant, and even more importantly, to show that it is valid. This is the very one. At the end of the presentation of the plaintiff's case, she will rest. The defendant then can put on a defense, and that's normally what happens. Every once in a great while, you'll have a defendant who, at the end of the plaintiff's case, has the lawyer stand up in front of the jury and say, "Ladies and gentlemen of the jury, I've sat here and I've listened to what the plaintiff has to say, and I got to tell you, for the life of me, I don't know how she can argue that she deserves anything. In fact, we think the case is so weak that we're not even going to put on any evidence, and we are ready for you to go into that jury room and come back with a verdict." Doesn't happen very often. It's dramatic when it does. But as with the plaintiff, the defense will put on witnesses, direct examination followed by cross-examination. Evidence will come from the witness box. Then the defense will rest its case. Now, at trial, Ms. Liebeck testified about the spill and her injuries. Plaintiff's expert testified that liquids at 180 degrees can cause third-degree burns in 2 to 7 seconds. The plaintiff's experts testified that most restaurants serve coffee at a much lower temperature, and that coffee made at home averages between 135 and 140 degrees. In its case, the defense presented evidence that it believed that its customers bought its coffee to drink at work or at home. In other words, they get this really hot coffee at McDonald's, and then they don't drink it until finally they're at work or at home, and it has cooled down to a drinkable temperature by the time they get there. But on cross-examination, remember this is where you're going to ask questions of the other guy's witness, a McDonald's witness testified that the company's research showed most customers drank the coffee as soon as they bought it, usually while driving. On cross-examination, the McDonald's quality assurance expert testified that he had not checked the safety of coffee sold at 180 degrees. We've finished with the presentation of the testimony. Both sides will make closing arguments. The close, Liebeck's lawyer said McDonald's coffee posed a risk to customers and had caused Ms. Liebeck's injuries. McDonald's said again, people know coffee's hot, they're supposed to be careful, and Ms. Liebeck is responsible for her own injuries. The finder of the facts deliberates and decides. Now, that deliberation form is very important because the deliberation form can frame a case in a way that is helpful either to the plaintiff or the defendant. And deliberation forms in a case like this generally would read, do you find from a preponderance of the evidence that McDonald's served its coffee at caused Ms. Liebeck's injuries? Do you find that Ms. Liebeck is in some way responsible for her own injuries? And there would be a question, what percentage of blame would you assign to McDonald's and what percentage of blame would you assign to Ms. Liebeck? They get this, they go back into the jury room, they deliberate, and they decide. Once we have a decision, there's a judgment, and that's based upon what the finder of fact. Now, Most of the cases are going to be jury cases. Occasionally we'll have a case that is tried to the bench, that is, tried strictly in front of a judge. But there's a judgment. In the Liebeck case, the jury found in her favor and awarded her $200,000. But the amount was reduced to $160,000 because the jury found that Ms. Liebeck was 20% responsible for her injuries. Maybe she should have waited till she got home to open the coffee. Maybe she should have gotten out of the car to put the sugar and cream in. Whatever, they said she bore some of the responsibility, so the total award is reduced by that percentage. The jury also awarded Ms. Liebeck $2.7 million in punitive damages. Now, let's talk about punitive damages. Punitive, well, it sounds like punish, and that's the purpose of these damages. Ms. Liebeck, according to the jury, is supposed to get $2.7 million, and what that $2.7 million is supposed to do, it's supposed to make McDonald's stop and think. Maybe we should sell the coffee at a lower temperature. We are just about to pay Ms. Liebeck $2.7 million. If we lower the temperature, perhaps we won't have any more lawsuits, especially since this lawsuit's gotten so much publicity. So that's punitive damages. Now, in the Liebeck case, the judge reduced the damages to $480,000. So with the $160,000, she's got $640,000 coming to her from McDonald's. Once we have the verdict, the judgment, then we have appeals. The losing party gets to appeal. The winning party doesn't get to appeal. In media law, appeals are generally based upon questions about the application of statutes, the application of precedent, that is to say prior cases in the same area, or the First Amendment itself. And so the question will be, did the judge properly apply the rules that regard expression? In personal injury cases like Ms. Liebeck, the appeals are mostly based on whether evidence was improperly admitted or improperly excluded. McDonald's appealed the case, but during the pendency of the appeal, settled the case for an undisclosed amount. But let's assume that the appeal is going to go on. The appeal goes to a higher court. The case was tried in a trial court, generally a district court. Then the losing side appeals to the higher court. The appellate court looks at the record. It doesn't take testimony again, but rather it reviews what was said in the trial. In our sorts of cases, it'll review what the judge said about the First Amendment or applicable statutes or precedential cases. In a personal injury case like Ms. Liebeck, the appellate court will look at what the judge did when someone tried to introduce evidence. If a trial judge makes an error, the appeals court has a couple of choices and how to deal with it. Number one, the appeals court could decide that the error was harmless, that it did not change the outcome of the case, no harm, no foul. But the losing side, the appellant in the appeal, is hoping that the appeals court will say the error was reversible. That is to say, the error changed the outcome. Without this error, the result would be reversed. The losing side in the appeal can then appeal to the next higher appeals court until you run out of appeals courts. Of course, the highest court of appeal in the United States is the Supreme Court. It is also a trial court for particular sorts of cases. We won't have to worry about it because we don't cover those sorts of cases in this class, and there are very few such cases ever. Supreme Court doesn't take every case. Number one, the issue must implicate the Constitution. Maybe a statute violates the Constitution. Maybe a decision by a lower court violates the Constitution. But the Constitution is at the heart of things. Personal injury suits like Ms. Liebeck would not get to the Supreme Court. This is the Supreme Court strength meter. A 9-zip, a unanimous ruling, is seen as a very strong decision by the court, likely to last for years. 8-1, there's some person who disagreed, 7-2, 6-3, and then we get to 5-4. 5-4 means that if one Supreme Court justice on the winning side changes his vote, it goes the other way. After the 5-4, we have a plurality. A majority of the justices agree with the result, but they do not agree on the rationale. A 4-4 tie means the lower court decision stands. And we can have a tie if a justice recuses him or herself. For example, in the affirmative action case before the Supreme Court, Justice Kagan recused herself because while she was with the Justice Department, She handles some of the government's work in that case. So that case will be decided by an 8-member Supreme Court. You have to ask the Supreme Court to accept your case. You petition for a writ of certiorari. Look it up in the book. It's a tongue twister. And the Supreme Court, through the action of 4 justices, decide to accept your case, or if they can't get 4 justices to say, we want it, it's denied. Your case goes to the Supreme Court. You send forward the record of what was said at the appellate court and the trial court. Then you put forth your reasoning as to why you should win and the other side should lose. Because it's the Supreme Court, in most cases, the pleadings will be supplemented by amicus briefs. Arguments will be made by amici, or friends of the court. And these amicus briefs can be persuasive at times, because the people speaking through the amicus briefs are people who are experts or authorities on the matter who say, I think this is the way you should go. The cases also feature oral argument, where the lawyers try to explain their cases. The justices can ask questions to clarify points of law. Occasionally they will make speeches. It's a surprising oral argument where a lawyer actually gets to say 30 minutes worth of words. When the justice is speaking, that's part of your 30 minutes. So there have been some cases in which the lawyer got out, may it please the court, and then they all chimed in. After the oral arguments, the justices have a conference. They get together. They take a vote as to which side wins. A justice on the winning side is chosen to write the opinion. That justice circulates the opinion in other justices' comments. Sometimes the comments change the opinion. A justice can write a separate concurrence, that is to say an opinion agreeing, but adding his or her own take. The losing justices can write dissents, as in the majority got it wrong, and here's why. Now, Supreme Court is important because it is the highest court in the land, supreme arbiter of the Constitution. Read the Supremacy Clause that says the Constitution is the supreme law of the land, and the Supreme Court is the last court to interpret the Constitution. We look at both majority opinions and dissents because, hey, even if it's a case where a justice is on the losing side, there are only 9 of them. So anything a justice says or writes could be helpful years down the road. And that concludes supplement number 1. I will send you emails to inform you of other supplements as the class continues.